All right. Good morning, everyone. Again, this is Tawny Broadbent, the Deputy Representative for the UN Women Multi-Country Office based in the Caribbean. I want to say a warm welcome to you and to the second session of Fulfilling the Commitments, Beijing Plus 25. This session is on violence against women, and we have with us the wonderful and amazing Roberta Clarke. Roberta Clarke is a human rights and social justice practitioner and advocate. She is currently the chair of the executive committee of the International Commission of Jurists and the president of the Coalition Against Domestic Violence. In 2017, she was UN Women's interim representative for Libya, and between 2012 and 2016, she was the regional director for UN Women's regional office for Asia and the Pacific. Prior to that, she was the regional program director of the UN Women Caribbean office, and for that we are ever grateful. She is a lawyer with postgraduate qualifications in sociology and international human rights laws. She has worked in various capacities with the University of the West Indies, the Caribbean Association for Feminist Research and Action, the Economic Commission for Latin America and the Caribbean, and as an attorney in private practice in Trinidad and Tobago. So just a reminder around the objective of these sessions. One, we're hoping to identify international commitments and jurisprudence in relation to the assigned theme. Today, we're looking at violence against women. We're looking at assessing the progress to date and acknowledging what the outstanding critical issues are. And the goal in the long term is to ensure that we are really contributing to what will be eventually a Caribbean position in relation to these issues to facilitate negotiations at Beijing Plus 25 as a Caribbean bloc. So without further ado, I'm going to hand over to Roberta and look forward to a really robust conversation and presentation. Roberta, the floor is yours.
Thank you, Tawny. Good morning, friends, brothers and sisters from across the Caribbean. I want to start off, first of all, by thanking UN Women and the Institute of Gender and Development Studies for the invitation to participate this morning in this 2-hour session. And I think, of course, we need all the opportunities that we can to come together to build common understanding and to build our solidarity and to remind ourselves of our personal and institutional commitments to achieve gender equality and in all of those dimensions. So my session, I think yesterday you had the first session with Dr. Barbara Bailey, and today my session is on violence against women. I think it's a deliberate title, violence against women, and of course UN Women calls it that, and that women are disproportionately the targets of certain forms of violence that either directly or indirectly intended to recreate unequal power relations, whether in the home or in the community or in society in general. So we are sticking with violence against women because and I guess we should say violence against women and girls, because that's what the focus of this will be. So first slide. I just wanted to set out what the objectives are today as I traverse these 22 slides. But my objectives are threefold. One, to outline, perhaps slightly tediously, the historical developments in standard setting or normative standard setting around violence against women and girls and gender-based violence. So in that regard, I'll be going through the development of the international treaties, as well as, I suppose, declarations and other kinds of soft law, such as the Beijing Platform for Action, for example. So I'll be going through that, and it will be about half of the presentation. Secondly, I will discuss jointly with you all what have been the Caribbean achievements against those standards and those norms, and what have been our limitations, and to discuss really together the why of the limitations, but also the why of the achievements. Because in thinking through the achievements, the why of the achievements, we perhaps get to think about the strategies that we can share with each other. And lastly, because this interaction or series of interactions is in preparation for the CSW session March, I think it's session 64, Beijing Plus 25 commemorations, we'll be exploring what the Caribbean objectives are or should be in participating in CSW. Now, the other thing I want to acknowledge is that some of this is happening in the context of what one might say is a maybe it's either a breakdown in communications, or it's a breakdown in resolve, or it's a breakdown in shared analytical understanding about where the Caribbean is in achieving non-discrimination and gender equality, and what needs to be done. So I think over the last few years, we have seen at CSW and at various international fora, the CARICOM consensus not being arrived at, because some countries have different points of view or reservations around some reliably contested issues: LGBT, sexual reproductive health and rights, for example, comprehensive sexuality education for children, and so on and so forth. And so towards the end of this presentation, I will be discussing some of those what I call more contentious issues with you, and trying to suggest that these really ought not to be contentious issues for the Caribbean, because really in the Caribbean we have resolved those issues in law and in practice. So that's sort of the outline of the presentation. I move now to the first substantive slide, and I want to suggest, well, first of all, I think it would be true to say that there's no topic that has attracted as much NGO women's movement attention as ending violence against women and girls. And I think that's not unexpected, because this movement starts off with women's organizations, and not necessarily feminist or activist organizations, but with women, not even necessarily even in organizations, but with women coming together to say, I know this is happening in my home, I know this is happening in my community, and I want to do something about it, and we need to break the silence. So that's the first phase. When we start, we go from voice, and I'm suggesting there's three phases, starting with voice, which means giving visibility to the issue, going towards the standard setting, and then finally towards action. So those are the first three. Those are the three phases I want to speak to, and I think that there's a fourth phase now in our activism and understanding, which is around intersectionality. And I don't have a slide on that. So when I get to the end and I don't speak about intersectionality, somebody please remind me. Yeah? Okay. So the first phase, visibilizing and telling the story. Second phase, theorizing the causes of violence and placing it within a human rights context. And third phase is the development of an integrated multi-sectoral state responsibility, really gender mainstreaming applied to violence against women. So starting with the first phase. That in the Caribbean, I think, goes back to the 1980s. In fact, the first shelter, I think in the English-speaking Caribbean, was started in Trinidad and Tobago, and it was started by the Sir Optimus Club, in fact, by someone called Radical Safe. And then the second one was about 1989, the shelter in Trinidad and Tobago. And in between that, the Bahamas, I think Dr. Sandra Dean Patterson opened her shelter. So this work around violence against women started off with the provision of services to women in harm's way, women and children in harm's way. It was very much a service-oriented development. Rape crisis centers also started. There was a phase for hotlines. It was just a phase for speaking out and creating visibility around the issue. It was also the phase for addressing stigma, which comes with being a victim survivor of gender-based violence. And therefore, all of that together, it was also a phase of empowerment, or the beginnings of empowerment for not only for women and especially affected by violence against women, but really for the women's movement to give voice to this issue and to plan for the needed responses at the level of the state and of the community to address all forms of violence against women. Now, I should say, when we talk about ending the silence, that ending the silence has really been, for the most part, around domestic violence, as we call it, intimate partner violence, as it is called in some of the legislation, and then to a lesser extent, unfortunately, rape and sexual assault, and then even less attention to sexual harassment. So the work really has been around domestic violence, and then to some extent around sexual assaults, in particular marital rape, and then around sexual harassment. Now, latterly, we're seeing also law reform around trafficking. But for the most part, I think the advocacy, I think it would be true to say, has focused on domestic violence. And that's not surprising given that domestic violence is the most prevalent form of gender-based violence the world over, as well as in the Caribbean. So I want to say by the early 1990s, I think you start to see the beginning of the second phase. And the second phase really is about standard setting and legislation, sort of creating a sense that the state has an obligation to do some things to address particularly domestic violence, but all forms of violence against women. And that's something that women's movement focused on was law reform, really and truly. That was, that period was really very much taken on in creating a legislative framework through which women could access protection and also through which the state would understand what its obligations were to prosecute and punish perpetrators of gender-based violence. So this was a period of standard setting both at international level and at regional level and indeed at national level, and those three things were happening all at the same time. And this slide just sort of sets out some of the main the main pillars of the standard setting, the main moments in developing norms around state accountability for responding to and ending violence against women and girls. I have the UN Universal Declaration of Human Rights as the number one, but of course that's back in 1948. But it does provide the framework for the development of all the standards that follow. As you know, Universal Declaration of Human Rights is not a treaty, it's not a convention, but it is so universally adopted that we call it customary international law. So it has the force of law, even though it's not a treaty. It was a declaration back then, but it has been adopted and it has also been embedded in many conventions or treaties which have been developed, signed, and ratified since the Universal Declaration, UDHR. So along the way, we have in standard setting the Convention on Elimination of All Forms of Discrimination Against Women. You all know about that, and it's been ratified by every CARICOM country. But is there something peculiar about the Women's Convention that you all want to? Anyone can say what they think is peculiar about it in the context of this conversation?
Jackie just said it did not originally deal with vote.
Yeah. Okay, you typed it.
Yeah,
okay,
some
good.
people will type. I'll read it for you.
No, I see. That's good. Exactly, Jackie. So it does not, in fact, deal with violence against women, though it does have something on trafficking, funnily enough. But then again, the international law on trafficking goes right back to the 1940s and 1930s. I mean, there's a long history on treaty development around trafficking in people. So it comes up in CEDAW, but violence against women does not. And that really is, and that convention was developed around 79, came into force, I believe, around 81. Think that in Trinidad and Tobago we had our first shelter in 85, and it would not have occurred to Radica. It must have occurred to Radica before 1985. So it's really quite peculiar that it's absent, but that just tells you how invisible the topic was back in 1981 there. Okay, so you have this sort of big lacuna in CEDAW. Then you have some CEDAW recommendations, which I will speak a little bit later about, the development of an optional protocol, which I think only 3 countries in the Caribbean, by the way, have signed and ratified. St. Kitts and Nevis, Antigua and Barbuda, and I believe Belize. We had the World Conference on Human Rights, which was a big moment as well in standard setting, 1993. The Rome Statute, which establishes the International Criminal Court. The UN Security Council resolutions of women, peace, and security. There are a host of them, at least 5 or 6 now. Of course, the 1992 Declaration on Elimination of Discrimination Against Women, which comes after the General Recommendation 19, Beijing Platform for Action, CSW 47. I want us to remember that one. We're going to come back to it. CSW 57, which was a few years ago. The protocol to prevent, suppress, and punish trafficking in persons, especially women and children, which is more recent but ratified by all CARICOM countries. The Sustainable Development Goals, in particular 5, but not just 5. And then the ILO Convention, which is a recent convention, June 2019. And Alexandrina is asking about Belém do Pará. Yes, I will get around to that. Those are, Belém do Pará is one of the regional conventions on ending violence against women. Yes, so it's not in this one because this is the international standard set in Alexandrina, but we will get to it a little bit later. Okay, so let's start off with the standard setting around General Recommendation 19, remembering that CEDAW itself really had nothing on violence against women. So the question which the CEDAW committee had to answer, and it did it in its general recommendation, how can we fill this gap, this huge yawning gap in the normative framework for gender equality? And we know that violence against women really is one of the main impediments to securing equality in the private as well as in the public spheres. So they did the general recommendation, and as you all know, each treaty body has a committee, and the CEDAW committee also has the authority to develop general recommendations, and general recommendations are meant to be an interpretive guide. They're meant to fill gaps and to give guidance to governments. And so using this really rather broad authority to fill gaps and to, interpret the convention, general recommendation actually goes through the CEDAW convention and says, under Article 1, under Article 2, under Article 3, under Article 4, this is how you weave in violence against women, how violence against women can be understood in an interpretative exercise looking at the CEDAW convention. So, 1992, sorry about that, 1992, developed by CEDAW, and it spoke to the relationship between violence and sex discrimination. Basically, what I just said, that violence is a manifestation. Violence against women and girls is a manifestation, is an expression of inequality and discrimination. And so therefore falls within the purview of the convention. And it was an important achievement, I think, in international human rights law, and it meant that the CEDAW committee could call upon states to account for their actions to end violence against women. And that's the real importance of the General Recommendation 19, which I think that we would probably also agree now constitutes international customary law, because it has not been disputed, and it's widely used by the committee in analyzing state party reports, and it's definitely widely used by all member states who are parties to the convention as a guide to, developing their periodic reports. But the real heart of human rights, and I want to say that and say it in many different ways as we go along, the real heart of human rights is this idea of accountability, and specifically state accountability, that the state has an obligation to protect, to respect, and to fulfill human rights. And so even though, for the most part, when we talk about violence against women, we're talking about non-state perpetrators, the CEDAW committee is saying because of the non-state perpetration of violence, whether in the home, in the community, or in the workplace, is so extensive that you can draw a line between this great prevalence and women's, the lack of equality between men and women. And because the state has an obligation to end gender-based discrimination, to end inequality, it also has an obligation to end all of the manifestations of that inequality, including violence against women. That's a really important point. Do we get that? All good on that? And that's what makes, when we say women's rights are human rights, that's really what they're getting at. Because we say, of course, women's rights are human rights. But what they're getting at is the idea that a lot of the violations that women experience, they experience it in the home. So it could just be like, one could look at it, I suppose, and it was looked at like that for much of history, that what happened between non-state actors was a private matter. What happened between, in Caribbean, we say that's husband and wife business. Yeah, it's a private matter. If an employer sexually harasses you at work, well, that's an employment relations issue. These are private matters. Find your remedy somewhere else. Get a divorce or, go to industrial court, whatever you have. That's your remedy. But the CEDAW committee was saying something much more profound than that. They're saying, given the extent of this violence, the state has its own very specific obligations to step in and act with what, another key concept in human rights, act with due diligence to end, to protect, respect, and fulfill women's human rights, even when the violation is at the instance of a non-state actor. Yeah? So really, that's the most important thing I want you to take away from, one of the most important things I want you to take away from this morning, that the success of women's movement is situating private violence in the context of public obligations and public accountabilities. And when we say protect, respect, and fulfill human rights, I don't know if you quite understand that or you've heard that phrasing before. So out of an abundance of caution, I'll just go through it quickly, that the state has in relation to all human rights, the state has a threefold accountability. The first accountability is to respect human rights, which is to do not to intervene, not to intrude, not to enter in areas where they will be disrupting or containing the individual rights to autonomy and freedom. So typically, a right to respect, an example of a right to respect would be freedom of expression. Yes, so don't intervene, don't try to stop people from having their free speech. Do not censor unless, of course, there's a legitimate reason to censor. For example, libel, if you're not telling the truth, or you're engaged in hate speech. So that's one example of the respect obligation. Other human rights related to respect are freedom of association, freedom of movement. Yeah. So that's respect. The other type of obligation that the state has is to protect and then to fulfill. So the three parts, right? And the protection obligation is to act with due diligence, again, to prevent violations of the rights of people by others, including by the state, whether it's a private or public actor, whether it's a police officer, or whether it's a doctor in your health center, or your partner in your home. That the state has an obligation to protect you from violations, yes? Particularly when those violations are connected to something systemic and discrimination related. And then the third kind of obligation that the state has is the obligation to fulfill human rights, and that is an active obligation to do things and to ensure that you access your rights. For example, in the context of violence, that means to make sure that you have a functioning administration of justice, to make sure that there are magistrates in the court, to make sure that the courts are functioning, to make sure that the police have police stations and vehicles and, can go to your home and extract or arrest perpetrators, for example. So an active doing thing, including prevention, having education programs, providing comprehensive sexuality education, all those things. Those are active things. So that's a three-part obligation that states have in relation to all human rights and also in relation to violence against women and girls. So as you go along, even after the session, I want you to think about when you are demanding from your government about what it should do, I want you to filter your demands through these prisms of protect, respect, and fulfill, and see what you get out of that. Okay, so coming back to the General Recommendation 19, it formed the basis of the UN Declaration on ending violence against women, and that declaration mirrors the definition in General Recommendation 19 of what is violence against women, and there's that definition. Any act of gender-based violence that results in or is likely to result in physical, sexual, psychological, or harm or suffering to women and girls, including threats of such violence, coercion, or arbitrary prevention, deprivations of liberty, whether occurring again in public or private life. So that's that. Next slide. So coming back to General Recommendation 19, it might be a bit tedious, and if you all know it, just let me know and I will skip forward. But understanding the causes and consequences was a big part of General Recommendation 19. And you see this restated over and over, and I think it was really important for the framers of the recommendation to say it. And in fact, next year it will be said again, because it's really important. This is contestation that continues around the public or private nature of gender-based violence. And you still find, for example, police saying, and people saying, oh, that's husband and wife business, even after we know that, even after we've recognized the public nature of the harm. So General Recommendation starts with that it is a form of discrimination that inhibits women's ability to enjoy their rights and freedoms on a basis of equality with men. That's a foundational understanding in all work around violence against women. And it's important because, you know, we often hear wherever two or three are gathered talking about violence against women, somebody will chime and say, oh, but men experience violence too. Is that not true? Somebody will always say, you know, what about men? Yes, of course, men experience violence, but what we're focusing on when we talk about gender-based violence is a violence that has a certain intentionality to it. The intentionality is to recreate, either directly intended or indirectly intended. The intentionality is to recreate a power dynamic in which women's inequality is perpetuated and recreated. So yes, we want to also acknowledge that men experience domestic violence, but the result of it is not the same, doesn't have the same implications for men. Of course, it's harmful for the individual man who's experiencing violence in the home, but the result is not a systemic structural reproduction of discrimination. And it's how we have to find a way of saying that so that men and boys hear what we're saying, hear that we care about what happens to them, but it's maybe a different framework to think about how we address that violence. Of course, violence against children is also an expression of power dynamics. And then one thing you always hear, and I hear it in the coalition all the time, oh, mothers are the worst perpetrators of violence against children. Okay. But again, that's also another dynamic at work, which is just to say that when we're talking about violence against women, it does not deny that there's other forms of violence equally important. We're just saying we want to talk about this in this way because it has this implication for inequality. Yeah? And I don't think we need to be apologetic about it. Okay, so in paragraph 6 of the general recommendation, they give an interpretation of Article 1 of the Convention, and they say that the definition of discrimination includes gender-based violence. That is violence that is directed against a woman because she's a woman, or that affects women disproportionately. And I would add the last thing to that, and has the consequence of reproducing inequality in the home and in the community. So they define what it means, and you see in all of these definitions of or examples of what gender-based violence is, you don't see financial abuse there, right? Physical, mental, sexual harm or suffering, threats of acts, coercions, or deprivations of liberty. But the financial violence is something that was added into Trinidad and Tobago's second iteration of this Domestic Violence Act in 1999, and I think has been followed in many of the other countries in the Caribbean. Anyways, so that's paragraph 6, which is extending Article 1 of the Convention to gender-based violence. Paragraph 7 of the general recommendation says that gender-based violence has an effect on the enjoyment by women of their own human rights and fundamental freedoms. And the rights and freedoms which are affected by gender-based violence is that long list of A to H. And that's really quite obvious, the right to life. Well, if you live in Trinidad and Tobago, it seems to us every other week or month, or every other week, a woman is killed by someone with whom she had an intimate partnership. And of course, in Latin America, for example, they have a term for that. They call it femicides because it is also so widespread. So gender-based violence definitely affects women's right to life. Many remain fearful of men. Even they may not be killed, but they have been threatened with murder, and they live lives of terror. So we definitely know it affects the right to life. And that life of terror is like torture, it's cruel, inhuman, it's degrading treatment or punishment. I want to say years ago, I represented two men on death row. I think I have told the story before. I don't know if you heard it. No, actually, it's another death penalty case. And the woman had been married off, so it's again about child marriage to Trinidad and Tobago. She had been married off to a man who was twice her age when she was about 15. When I say either married off or sent into a common law union, but her family sent her to live with this man in the country, and he was twice her age. And she had like 5 or 6 children with him, one after the other, and he used to abuse her terribly, physically abuse her. And then when he really wanted to mentally torture her, what he would do would line her children up against the wall, also his children, and put a gun to their head or walk down with a gun to their heads to terrorize them and to terrorize her. Well, that's what we talk about. We talk about cruel, inhumane treatment. which you have a right not to be subjected to. The right to equal protection according to humanitarian norms in times of international or internal armed conflict. And I suppose now, if the CEDAW committee were to rewrite this line, they would also include disasters, humanitarian crises which arise out of disasters. And we do know in some countries, in times of disasters, there's a spike in gender-based violence and specifically in domestic violence. It affects the right to liberty and security of the person. That's rather straightforward and obvious. The right to equal protection under the law. Well, that's also one that's quite profound, because what we do know is that under all of our constitutions, we are guaranteed equal protection of the law, but often women cannot access the law, meaning the police or the courts, security systems, one, because they're fearful for their lives, or the police station may not be anywhere near them. If you're living in a rural community, you don't have any access to police, and you can't get there because maybe you don't even have the money to travel to get to the police station. And when you do get to the police station, they may not give you the kind of response that you need to secure your protection. So that's equal protection in the law. We know definitely many women who are suffering domestic violence cannot access equal protection under the law, and including also sexual assault, rape, because all the rape myths that still operate in our societies to grant impunity to men who violate women's personal autonomy. And that's a question of culture and cultural norms change, which we have to engage in. The right to equality in the family, well, that's pretty obvious. The right to highest standard attainable of physical and mental health. Of course, many women who are living and girls who are living through violence suffer depression, and it really can have a powerful distracting impact on the rest of their lives. And finally, violence, gender-based violence, can affect the favorable conditions of work. Now, in a number of ways, just generally, if the violence is sexual harassment, that by itself is interrupting conditions of work. But then there are many women who experience violence in the home, and they may not be able to come to work because of injury and may face loss of job, employment, or they may have to go many times to the court to seek their protection orders, as we have in Trinidad and Tobago, where there's so much delay in the legal system. And I do know of some cases where employers have dismissed women for seeking days off to go to the court for protection orders. And I should just say on the side, parenthetically, one of the things that the coalition has just recently done with the Chamber of Commerce here in Trinidad and Tobago is develop a national domestic violence workplace policy that would give employers guidance on how they can better support persons who are especially affected by gender-based violence in the workplace. And we can certainly share that with you all if you all are interested in looking at it. Okay, still on General Recommendation 19. What's interesting about this, the convention applies to violence perpetrated by public authorities, not just non-state actors. Now, that public authorities is an important one because there are sectors of women, populations of women, who really are harassed and beaten and violated by public authorities. And for example, in the context of HIV, there are many a meeting I have attended where sex workers say, how vulnerable they are to sexual extortion and to violence, arbitrary containment of their human rights. And maybe you all have heard some of those stories as well. Someone said right of domination by Lazarus. Yes, that's the study on the court's treatment of women in domestic violence cases in Antigua and Barbuda, I believe. Yes, thanks, Alexandrina. Okay, so back to General Recommendation 19. So that discrimination under the convention, this is a reiteration of the application of the convention to private actors. The CEDAW emphasized over and over that discrimination under the convention is not restricted to action by or on behalf of governments. So for example, the convention calls on states to take all appropriate measures to eliminate discrimination against women by any person, any organization or enterprise. And under general international law and specific human rights covenants, states may also be responsible for private acts if they fail to act with due diligence to prevent violations. And there's that famous case from Latin America where this due diligence principle was enunciated. I think it's Velasquez, and maybe Tracy Robinson will speak to you all when you get to her session, which outlined the state's obligation, the state's responsibility and accountability to act with due diligence to prevent violations. In that case, it was around disappearances in Central America. So that was General Recommendation 19, and out of General Recommendation 19 came the first declaration. Of course, as you know, there's no international convention on ending violence against women. I think that there's a lot of hesitation to do that, given the unpredictability we would have to see of the multilateral system right now. But there are regional conventions, as Alexandrina pointed out, but no equivalent convention. So we're still left with General Recommendation 19. We'll talk a little bit later about General Recommendation 35, which updates 19 as the framework within which CEDAW is understood. So outside of Recommendation 19, other things happened in the 1990s to create a lot of visibility around violence against women and visibility for the purpose of enunciating human rights standards. One of those big moments, for those of you who were engaged in the moments in the 1990s, was the Vienna Conference on Human Rights in 1993. There was a caucus of women's organizations who worked to ensure the inclusion of language focused on state responsibility to end all forms of violations against women. I want to say something specific about that. Yeah, that it was also around that time of the Vienna conference, the International Criminal Court statute was also the Rome statute was also being negotiated. Now, do you all know how the Caribbean is related to that statute? Does anybody know? That in fact a Caribbean person was one of the motivators or influencers of that statute. And maybe the rest of you may not know, but Trinidadians should know that in fact this idea of the International Criminal Court was mooted by A.N.R. Robinson, who was for some period of time the Prime Minister, well, first an Attorney General in this country, then the Prime Minister, and then the President of the country. He was one of the first people to call for an International Criminal Court. I don't think he was quite thinking of the court that was exactly set up, but all the same, it is very recognized that that Trinidad and Tobago was behind the establishment of that court, and that court has always had a Trinidadian judge on it. Little known fact. And right now, the sitting judge on that court is Geoffrey Henderson. So yeah, that's an aside. But around the time of the Vienna Convention, the Rome statute was also being negotiated, and it was really important. It was also the time of Rwanda, as well as the genocides in Bosnia and Serbia and Herzegovina, former Yugoslavia. So a lot of conversation around the time was how would you take this violence against women that's happened in the context of war and codify it for states to have an obligation to prevent violence against women in the context of conflict and war. So that was also really an important moment. So rape, sexual slavery, forced prostitution, all these things were recognized as crimes against humanity. And really, that was really a powerful moment of victory for women's human rights. So that was happening around the same time of the Vienna conference. So following this conference, the conference document called for the establishment of a UN mechanism to focus on violence against women, and that focus was that was the Special Rapporteur on Violence Against Women, its causes and consequences, who was appointed by the UN Commission on Human Rights. And since 1994, there's always been a Special Rapporteur on Violence Against Women. In fact, now there's also a Special Rapporteur on sexual violence in the context of conflict, and so on and so forth. There's a lot of movement around UN mechanisms focusing on violence against women. Okay, so here we come to So those were the main international developments up to the 1990s. And around that time, we also start to see the development of regional human rights standards. And in fact, in this region, Latin America and the Caribbean was the first region to have a regional convention. And as you know, it's the Belém do Pará, and Alexandrina has already referred to it. And it's a convention on the prevention, punishment, and eradication of violence against women. And you see there already prevention, punishment, eradication. You see that you see all the elements of multifactoriality. Yes. Eradication, this is about cultural change, prevention about cultural change, punishment has to do with the response, and ending impunity. So Belém do Pará is quite a robust convention and reads well 20-something years later, reads quite well. The other next sort of convention was the African, in the context of Africa, the Protocol of Rights of Women in Africa, which supplemented the African Charter on Human Rights, and it calls on states to take measures to prohibit all forms of violence against women. And the third in the line was the Istanbul Convention, was the European Convention on ending violence against women. That one is of most recent vintage. I think it might be 2010 or 2011, I'm not sure. But surprisingly, there was a lot of resistance to developing a convention in Europe. I think only because they felt that they would not want to open negotiations that would lead to a standard lower than the General Recommendation 19. But I think that they were able to do that, and Istanbul Convention is quite a robust one as well. So those are your regional regional norms that focus on violence against women. Apart from that, we have what we call soft law. So the regional conventions like CEDAW, these are what we call hard law. They're treaties, they're conventions. States, once they sign and ratify, are bound by their promises, and it creates opportunities to complain if they do not comply with their obligations under these conventions, and the mechanisms of complaints which are established in international human rights law, and that's for another moment, not for now. But to say one of those mechanisms under CEDAW is the optional protocol, and to repeat, the only 3 countries in the Caribbean that have signed the optional protocol are St. Kitts and Nevis, Antigua, Barbuda, and I believe Belize. Anyway,
You're right. Belize is the 3 that you've highlighted.
Yeah, all right. So, I mean, so that's work for the rest of you all to do. Maybe that's the gift that member states can give the Caribbean in 2020 as they go forward with Beijing Plus 25, which is to sign and ratify the optional protocol. Maybe that could be one of the, maybe that could be one of the things to do or things to advocate for together on the part of women's movement in the Caribbean. And in fact, the optional protocol has been really important, particularly for the countries in Eastern Europe and even, I believe, in Asia, who have taken on men who have taken quite a number of cases to the optional protocol around state non-compliance to end violence against women. So I think it's definitely something that we should be pursuing much more rigorously in the Caribbean. Okay, so apart from the conventions, you have a series of soft law or just declarations. And you all will all know the UN Security Council Resolutions 1325, Women, Peace and Security, which provides a framework for addressing women's need for and rights to protection during conflict. There's a few main elements of it. One, of course, women's participation rights, but secondly, the obligation of the state to protect women from gender-based violence. Yes, what I wanted to remember to say when I talked about the ICC and rape, that in fact, rape of women was seen as the spoils of war for most of history. It was quite accepted that pillaging men would go into villages and that they had conquered and raped the women. And one of the things that I really had not understood growing up as a child was that in World War II, a big part of what those men did, Russians, French, English, Americans, Japanese, a big part of what they did was rape. And millions of women were raped by all forces during World War II. And I think that's something that's not spoken about enough, given how extensive it was, in a way in which, there is a tendency, I think, in the global North and global South dialogue to think of violence against women as somehow a global South issue. I mean, I don't want to raise that red herring necessarily, but just to say that systemic use of rape in conflict is very much part of the global story of violence against women. And, you know, even now we're hearing it, the raping of women in Myanmar by the Burmese army, the Myanmar army. We're hearing, of course, about all the violations in Syria and the Kurds, very much part of the story of war, violence against women. Okay, so I want to get on to phase 3 and maybe go through that more quickly. Phase 3 really is about mainstreaming, and that's what the Beijing Platform for Action really is. A big achievement of the Beijing Platform for Action, which, by the way, I think is a beautiful, beautiful document. It withstands the years. You can read it. It has a very integrated understanding of the complexity of the challenge. And we focus a lot on violence against women in the Beijing Platform for Action. But the Platform for Action also has a section on, let me get it, women and armed conflict, and where they speak about, you know, the right to peace, not just the right to non-violence in the home, but the right to live in peace. And it's a fairly subtle political economy argument in the Beijing Platform for Action, because the member states then, and really with women's ministers from around the world, said we have to decrease the militarization, we have to reduce expenditure on weapons. This is a big part of women's vulnerability in conflict, and it's also connected to violence against women in the home, because what you're doing is you're reproducing a certain kind of aggressive masculinity with this concentration on militarization and weaponry. But that's a lot of that gets lost when we talk about violence against women, because we're so focused in on domestic violence. So just something for us to be thinking about, because again, in all of our countries, a big part of the response to crime and violence is weapons. You know, a lot of the investment in crime and insecurity in these countries is about giving police more hardware, as opposed to, you know, other kinds of approaches which are more about social development and social justice and education. So the Beijing Platform for Action really is about mainstreaming. How do you have a whole of government approach to doing all of these things, because they are all integrated? You can't talk about violence against women without talking about poverty, without talking about women's access to health, without talking about education, and so on and so forth, right? That you need a whole of government approach to do all of that. And that's really the main thrust of the Beijing Platform for Action. Again, that Beijing Platform for Action restates, and it's a recurrent decimal, and you're going to find it again next year being said, the state has a duty to act positively to end discrimination, and that means that the state has the responsibility to ensure women's protection from all forms of violence, whether perpetrated by a public or private actor. Over and over and over, the connection between discrimination and equal power relations and gender-based violence. So I'm going to run out of time, so let me run away from that. The Platform for Action addresses violence against women, has 3 strategic objectives. One, that we need to better understand causes and consequences. So it's really about getting the evidence and looking at the effectiveness of preventative measures. Again, what is the evidence of what works? Secondly, that you have a whole of society, not just government, a whole of society obligation to take integrated measures to prevent and eliminate violence. And thirdly, a specific focus on trafficking in women and assisting victims of violence due to prostitution and trafficking. Now, probably this strategic objective will not be written like this now, because there's a whole lot of discussion around sex work and the rejection of conflation of sex work with trafficking, which this strategic objective seems to suggest. So that's something we can discuss a little bit later on. Okay, so that's the third phase, I think, after Beijing Platform for Action, is this idea of developing integrated multi-sectoral actions. You know, we start hearing about national action plans, generally speaking, for ending gender inequality, but also specifically for addressing gender-based violence, and that the health and education and administration of justice and security and housing and the economy, all these things have to work together to create the enabling environment to transform unequal relations, to end harmful practices, to interrupt negative, harmful gender stereotyping. All those things have to happen. So we're talking about whole of society, not just whole of government, whole of society obligation to do kind of integrated planning and programming. And then I want to focus in quickly on CSW 57, which I think was back in 2013. I can't remember what year it was exactly. But again, that spoke a lot of, you know, all along, in 2000, and 2005, and 2010, member states got together to report on what they were doing to implement the Beijing Platform for Action. And one of the recurring decimals in relation to violence against women is the under-implementation of domestic violence legislation and policies and the absence of plans. So while there was a really nice normative framework or understanding about what states should do to protect, respect, and fulfill, generally the states were not doing it, or at least with the speed that they should have been doing it. So that's a recurring complaint at all Beijing pluses. And I think you will hear it again. You heard it Beijing plus 20, and you're going to hear it again at Beijing plus 25. But we have made some progress. So CSW 57 asks for strengthened implementation of legal and policy frameworks and accountability. And accountability, I think, is a big word here. Addressing the underlying causes and risk factors. So let us look at the economy, let's look at economic empowerment, and so on and so forth, right? Addressing, strengthening multi-sectoral services, and out of that we have the essential services package, which is being piloted or what's the word I want, executed by the UN agencies, including UN Women and UNFPA and UNDP. So to strengthen multi-sectoral services and improving the evidence base that we need to know a lot more about violence against women, in particular prevalence, because there's so much underreporting. Administrative data is so full of gaps that prevalence surveys were the way to go. And I think UN Women has been promoting prevalence surveys in a number of countries, and we hope that you can, I don't know if UN Women intends to, but hope that they can give us some fact sheets before March next year on what their prevalence surveys are finding for the Caribbean. Okay, I don't want to go into more of that. I can send you all the presentation because I'm running out of time. I want to just speak a little bit about General Recommendation 35, which is the updating of Recommendation 19. Now, it doesn't replace 19, but it updates it. And so these are a few things that it adds. So it was important to recognize that prohibition of gender-based violence is a norm of international customary law, which means that all member states agree that they have an obligation or a responsibility to protect, respect, and fulfill women's rights to lives free of violence. That's what that means. It expands the understanding of violence to include violations of sexual and reproductive health and rights, which is why SRHR comes up in every conversation around violence against women, because we know these two things cannot be separated. It stresses the need for social norms change and ending stereotypes that support violence. So you see a big focus on prevention, social norms change and prevention, which cultural change, which you don't see in previous norm standards and soft law. It speaks to the resurgence of cultural, traditional, or religious narratives that threaten the concept of gender equality. You know, many countries still have reservations to particularly Article 5 in CEDAW, which talks about cultural practice, not justifying, cultural practices cannot be invoked to justify discrimination. And many member states have signed CEDAW but have reserved on that. And again, in General Recommendation 35, the CEDAW committee is saying, in fact, this is non-negotiable. You cannot use culture, tradition, or religion to justify gender inequality. It defines rather clearly different levels of liability of the state, including failures to prevent violence at the hands of private individuals and companies. And it's now focusing on access to remedies, not just protection for survivors. And I think that we in the Caribbean are a little bit ahead of that, because in some of our legislation, particularly in Trinidad and Tobago, there is the 1999 Act does speak about compensation for victim survivors and remedies, but also including financial compensation. And again, lastly, not lastly, but what the last thing I want to say about that, it also connects women's autonomy and decision making with the efforts to end violence against women. I'm not saying too much about SDGs. This is, of course, we know about SDG 5, which is a standalone gender equality goal, and there are specific targets and indicators addressing gender-based violence. But what I have this slide up to say is you must not only look to SDG 5 to to see what has to be done to end violence against women and girls, the other SDG goals and targets that are directly relevant. And I have two here. In the target 3.7, which comes under health, ensure universal access to sexual reproductive health care and services, including for family planning and so on and so forth. And then under 16.2, 16, by the way, is my favorite SDG, end abuse, exploitation, and trafficking and all forms of violence against and torture of children. But SDG 16 really is about rule of law and peaceful societies, the real systemic change and good governance. So have a look at it. Okay. So where in the Caribbean are we? This is just a short slide to give a synopsis. All countries have domestic violence legislation. Some of them are on their second, have on their second iteration. Trinidad and Tobago will be starting its third iteration, I suppose next year. The promises were made this year for revision to the law, which is still pretty good. Very few countries have sexual harassment laws: St. Lucia, Belize, Bahamas, BVI, Guyana. But for the most part, we don't have legislation which gives a remedy and protection for someone who's sexually harassed in the workplace. So that's work to be done. Marital rape is fully criminalized only in Trinidad and Tobago and Guyana, and also in the countries where the common law is relevant. So there was an old English case which also, basically removed all immunity for rape within marriage. So the countries that still use the common law around rape, they will benefit from that full criminalization of marital rape. And I think those are countries in the Eastern Caribbean. And then you have partial criminalization in Jamaica, Bahamas, Belize, BVI. And in those countries, if you are separated from your partner or divorced or in the process of getting a divorce from your partner, in those cases, rape will be criminalized. But if you are married and living with the person, not. Well, of course, that's ridiculous. So those countries still have to get with that program. But these partial criminalizations are pretty recent. And Elaine is saying marital rape is also fully criminalized in Grenada. Well, I think you are fully criminalized because of the common law. Elaine, do you have it codified? You can tell me. But certainly, that's that. Okay, and we have trafficking legislation practically everywhere. We have national action plans, not that many countries with it. I may not have a full list, but this is what I extracted from UN Women. Bahamas, Jamaica, Grenada, Belize, and Kitts. We have violence integrated in national gender equality plans in Suriname and Dominica. And then I have something here called Caribbean Consensus, which the colleagues can send you all. But this was a document prepared in 2013, which outlined the Caribbean countries' negotiating strategy for Beijing plus 20. So that's something that you can have a look at. Doesn't Barbados have a plan for trafficking? I'm sure, I don't know, but you can let us know, Nicole, if it does. I think all of them have and by the way, all countries have ratified the convention, the Trafficking Convention, Prohibition of Trafficking Against Women and Girls Convention, but I'm not sure all have legislation. And I'm not sure all have action plan either. But so that's something to think about. Okay, so the challenges, I think political will, I think is a big challenge still. We have good laws, which are the foundation of victim protection and offender accountability, but implementation and monitoring is key, and I think we don't have effective implementation. We don't have adequate funding, support for victims. Well, hopefully for the country so lucky to get spotlight, that will cause some trigger, that will be a trigger and cause some, and catalyze for real fundamental deep efforts to transform the cultures of inequality and violence in our societies. But I think those are challenges on the implementation of the laws and policies and an absence of a systemic and structural approach to cultural change, particularly in the education sector. All right, nearly done. Okay, so these are the things that come up every year. The question of I think in very few countries, LGBT persons are not protected. They're not included in domestic violence legislation, and that's a discrimination. And I think that it comes up every year at CSW. Reference to LGBT is always contested by member states. And I think in the Caribbean, we have no legal or moral authority to contest that. By that, which I mean to say that we now have three judgments, court judgments that speak very clearly to the fact that criminalization of consensual same-sex intimacy is unconstitutional. It's against, it's a violation of our fundamental rights and freedoms: right to family life, right to privacy, right to equal protection of the law. In Belize, the sodomy laws were struck down. In Trinidad and Tobago, similarly, it was struck down. And in a wonderful case from Guyana, which I encourage you all to find and read because it's highly readable, is the case of McEwen and others, Caribbean Court of Justice case from Guyana. Basically, the court found, and it was a case of trans women who had been charged for cross-dressing for an improper purpose, whatever that means, and other things. And our final appellate court for Guyana and for Belize and for Barbados and for Suriname and for Dominica, CCJ is the final court for 5 countries, final appellate court for 5 countries. That court basically recognized that persons who live non-binary gender identity and sexual orientation are equally entitled to non-discrimination prohibition, like anyone else, and that sexual orientation was a basis, was a prohibited basis for discrimination. So really, a really, really important case. So we go up to CSW and say, well, our country doesn't have a position on LGBT or LGBT intimacies against the law in our country. Many of our countries will not be able to say that again, because the CCJ has settled the law for the 5 countries, and then there's Trinidad and Tobago, and then there's Belize, where there was also a challenge. So at least for 6 countries, the law is settled that discrimination on the basis of sexual orientation and gender identity is prohibited, and that has to inform our negotiations now, because that's settled. And for the other countries who are not, for whom CCJ is not the final appellate court, certainly CCJ's decisions are highly, highly persuasive. So I just wanted to say that about that. The other challenge, okay, so this is just a quote from the CCJ, which I love and adore, but I don't have time to read it, but you all can get it. The question of abortion and women's autonomy over their bodies comes up a lot, again, at CSW. And again, I'm saying from the Caribbean, if we understand what our law is, we should not be objecting at all to language which speaks to women's right to sexual reproductive health and services and sexual autonomy, because the law in the Caribbean, for example, all across the Caribbean, permits abortion if in the interest of women's life and health includes mental health. And there are cases that also say mental health also includes economic deprivation. So it's quite an expansive definition of what is life and what is health. And of course, for Barbados and Guyana, abortion has been decriminalized for quite a long time, and now is regulated. So we do, I think, almost have to say in the Caribbean, there's a lot of settlement on women's right to access sexual reproductive services, in particular, safe abortion. At least I would argue that. And then on the question of comprehensive sexuality education, which it seems strangely enough Caribbean governments are hesitant to provide, I think that many treaties that Caribbean countries have signed, treaty bodies have said, in fact, that the state has an obligation to provide education. And in that regard, I just wanted to read something quickly from the Beijing Platform for Action, where let me read it quickly, where the state is called upon to prepare and disseminate accessible information through public health campaigns, reliable counseling, and the education system designed to ensure that women and men, particularly young people, can acquire knowledge about their health, especially information on sexuality and reproduction, taking into account the rights of the child to access to information, privacy, confidentiality, respect, and informed consent, and so on and so forth. That's in the Beijing Platform for Action. So we've already agreed to Beijing Platform for Action. Why are we going back on that every time we get to CSW? I think, we have to, I don't want to sound as if I'm on a soapbox, but we have to be negotiating with integrity. And the Caribbean has already agreed on that, and we have bound ourselves. It cannot be for a few people who don't understand the history of negotiations to go to New York, sit in CSW, and do all of the good work that we have done. So I think this question of contestant culture is also important, but I've said it already. I think that there's a lot of jurisprudence that tradition and culture and religion cannot be invoked to justify discrimination in any regard, including LGBT-based discrimination. So I want to stop there. I've gone a little bit too long, but I think we have like 45 minutes or maybe 50 minutes. And I want to ask 3 questions, or you all to talk amongst yourselves. But one of the things I want to ask is, in what way do you think Beijing plus 25 can advance your work? What are the things we should be talking about with each other? And the other questions, what are the main challenges in your country? And you may have questions yourself. Thanks, Elaine. Criminal Code Amendment of 2012 added rape of a spouse as a criminal offense. Thanks.
And Roberta, Barbados in their labor code has now addressed sexual harassment, but only so far as sexual harassment in the workplace legislatively. So we're opening it up to everyone else. Please unmute yourself, put your questions in there, and the floor is open for real dialogue and conversation.
Yes, hi, this is Michelle from Belize, and we are one of the countries that are receiving the Spotlight Initiative. And I think some of the things that we were discussing, we're trying to see how we would be able to cover some of them in terms of policy. For example, one of the things that we were looking at was the sexual harassment law. Belize has this law since 1996, I think. However, it seems that there have not been any case that has been brought to the court using this law, and the law covers workplace, tenancy, and institutions. So we have work to do as it relates to some of the maybe regulations as it relates to the law, or how we could ensure that the law is being used by knowledge by the community, 1, and 2, to ensure that how we access the law. I think the way how the law was introduced, it's a little bit different from other laws, so people are not certain how to engage the courts as it relates to the law. And I think the broader question of gender justice and issues of access to justice in the context of gender-based violence also come into play. And so those are some of the issues, I think, as it relates to, I can see right off the bat, as it relates to policy development and the way we move forward.
Hello, Antigua here. In Antigua, what my organization has found is that there are some companies, private companies, that have developed their own gender policy. And so they have dealt internally with any form of harassment in the workplace. Also, in recent discussion with the director of labor in Antigua, they are looking at the recent ILO document, and they propose to have some consultations later in the year in order to develop a policy and also look to how we can frame a sexual harassment act or bill for Antigua Barbuda. So that is for that is for policy development. What may be impeding it, I said it yesterday, and I'm going to say it again today. We need to really consider how the 5-year cycle affects policies and some of the challenges that we continue to face in our Caribbean countries. Our administrations tend to pander to the electorate, and in so doing, a number of the hard work that we have already done through the years continue to be pushed on the back burner. And when NGOs raise their voice, as it were, you are seen as anti-government, whereas we're looking to help them to fulfill their national and international obligations. Another area we need to look at is the role of some faith-based organizations that are being funded heavily from the north that are speaking out loudly against the whole issue of human rights when it comes to the issues of abortion and LGBT rights. Roberta did say at the end of her discussion to remind her to talk about intersectionality. So I wouldn't say anything, but I'll leave her to deal to say what she has to say about that. How do we think the Beijing 25 can advance our work? For some NGOs, sustainability is a major challenge. Some NGOs in some countries receive subventures from government. Some do not. There's also a underpinning challenge with some NGOs who may receive subventures from government is that they may have to toe the line when it comes to speaking out on certain issues. So that's my input at this point in time. Thank you.
Roberta, I'm not sure if you're seeing Nicole Aline's question with regards to the gray areas in the legislation being clarified as well. And then, we're opening it up to more people to please also share your thoughts. Thanks for that, Alexandrina and Michelle.
Maybe we can have some conversation around the questions. On intersectionality, I want to say I think that I talk about 3 phases. I think that's phase 4, which is that we will have to both talk in commonalities as well as in differences. So we know that all women and girls are not equally vulnerable to all forms of violence, and some are more vulnerable than others, and some have less access to justice and services than others. And I think that we have to start, disaggregating in our language. One of the things I wanted to point out is that the Convention on the Rights of Persons Living with Disabilities has an article, I think it's Article 16, which speaks about violence and exploitation of persons living with disabilities, and also has a definition of gender-based violence and violence against women living with disabilities. And so again, we have there are other spaces where we can look to see what are the state obligations, and certainly that convention is also one of the places which I don't think we've paid any attention to. I've heard very little about that in the Caribbean, referencing the convention on the rights of persons with disabilities. We don't talk about it in the context of violence against women, and we have to start talking about that because that's a real vulnerability and risk. And of course, the access of LGBT persons to justice, we have to also speak much more forcibly and in solidarity around that. I don't know that there's any, I think maybe Barbados has some sort of gray area there, but certainly in Trinidad and Tobago, same-sex partners can't access the court for protection orders, and that's the case in most countries in the Caribbean. And that really is unconstitutional, and that really is wrong. One of the implications when the High Court in Trinidad and Tobago struck down the criminalization of consensual same-sex intimacy, the state has appealed it, and the state said it was appealing that decision only because it needs clarity, because there are many other statutes that will have to be repealed or amended, including the Domestic Violence Act, which excludes same-sex persons from accessing protection. Similarly, the Equal Opportunity Act explicitly also excludes same-sex people from complaining about discrimination, and that really must be unconstitutional, and we'll get around to finding out that. So I'm just saying, I think that the next phase is a phase that will, again, where we have to be much more astute about our demands for implementation. We have to be evidence-based. I think we can't just be rhetorical anymore. We have to come up with the evidence of the system failure. And just recently, because I'm preparing for something for next week, I was looking, for example, at the statistics on the courts, Eastern Caribbean Supreme Court and Trinidad Judiciary. And I mean, there are thousands and thousands and thousands of applications for protection orders, and just applications for things related to family in the magistrate's court, and that the magistrate's court is bedeviled with inefficiency, is overburdened. Women go there repeatedly for protection orders, don't get that, and every time they go, they're exposed to harm and to threats. I mean, so we have system failure, but we have to be able to say what are the dimensions of system failure. And we have to say it pretty fearlessly. And I hear you, Alexandrina, about subventions, but I think women's organizations have to free themselves of, I mean, and I know it sounds simplistic, but we do really have to go back to self-determination, where we say what we have to say, just as you do, Alexandrina, whether or not we get subvention. And all that means that institutions like UN Women, I'm sorry to put you on the spot, Tony, that the UN agencies have to be supported in women's movement better, not to get women's movement to do their work, to support women's movement on their own steam. Now, I think that's the promise of Spotlight. For those of you who don't know, at least 15%, I believe, of the Spotlight envelope has to go to women's organizations to do what women's organizations want to do, to strengthen them. And then between 40 and 50% of the rest of the money has to be implemented by civil society and women's organizations. So I think we are going to have we're going to have resources in this region which we have not had for a long time, or maybe never had. And it is really for civil society organizations to really work together, not to fight over the money and to compete and to hold secrets from each other, but to really work together to deliver change for women, or else we are no better than the government, so we want to criticize. I want to stop there. And Nicole says, what I would like is that those NGOs who are pioneers in domestic violence are recognized and included, yes, rather than yes. I agree with that. I think you have to recognize the old ones and you have to include the new ones. And, so yeah. And I think, one of the things that we want to do here in the coalition is to have some sort of annual recognition of not just the pioneers, but those activists who are spending a lot of their time on this work. I think, we amongst women's movement, we have to start acknowledging each other better than we have been doing it. And, we definitely have to be building our solidarity. Yes, 15% for CSOs, yeah. The gray areas in relation to domestic violence, don't leave it up to the judge or anyone's interpretation. Okay. Well, I mean, the judge does have to interpret the legislation and does have to make a decision on what they believe based on the evidence before them. So you can't really get away from judicial discretion. I mean, judicial discretion is just a fact of the rule of law, because people have to interpret words and they have to say, do those words, as I understand them, do they apply to your scenario? So I don't think there's any getting away from that. I mean, gray area is embedded in all law, because you can't really put in all law every specific scenario. You can't even foresee every scenario that would happen under legislation. So you do have to have judicial discretion, but judicial discretion is not open-ended. Judicial discretion has to be exercised reasonably, and it is reviewable. And that's why you have the appeal court, and that's why you have judicial review, because all the time discretions are being reviewed. Judicial discretion is being called into question. If it's arbitrary, if it's unreasonable, if it's disproportionate. There are lots of devices in law that can tell you what are the parameters of judicial decision making. But the problem with judicial review, which is a powerful tool, is that you need a lawyer. And a lot of people who go to magistrates courts are people themselves who hardly have anything even to feed their children. They don't have access to legal aid and they don't have access to resources to challenge where you may have a misuse of judicial power. So I do see that point. But I think, again, that is for us to, years ago, NGOs used to run legal aid in the Caribbean. In St. Lucia, there was a wonderful legal aid run by the Catholic Church. I don't think it exists anymore. Well, Grenada's legal aid is still there. But many countries, there is no legal aid. But that's something, I guess, for us to think about and work on as well. And Sharon reminds us of the judicial bias. Yes, of course, unconscious bias is a big pattern across the Caribbean. And I think there's been a lot of work being done by the CCJ, supported by UN Women. URAP has been doing a lot of training of judges, University Rights Action Project on conscious and unconscious bias. And that's really important work that has to continue. But not only must you train, you have to monitor. So one of the things that I really would like for us to be doing is to have court monitors, and that's one of the things that the coalition hopes that we can get going soon. So people to actually observe the court and record what the court is doing. So that's also an accountability mechanism, but that of course requires time and some resources to do. So training is one thing, but you have to monitor what happens after the training. And then Yakub saying, what I can say is that this has prioritized improvement of the capacity of Department of Gender Relations and development of policies and sustainable tools to monitor and evaluate progress. Also, in addition to conducting a review of Beijing this year, we also for the first time presented our voluntary national review. Okay, SDGs. Yeah. Yes. Yakub, were NGOs involved in all of that? The NGO movement, was it involved in the preparing of the documents and the reporting?
One of the things that I remembered concerning that was, good morning, everyone. Good afternoon. My name is Yakub Nestor. One of the things that I do remember, because I think that was a press release because I work in the ministry and I work in education. I think we gathered the support of ECLAC, ECLAC, yes, I think they were our consultants. So what we were trying to do was to support the development of a national gender policy statement and strategy. And the other thing was to conduct an assessment of the production and management of gender data in St. Lucia so that we can actually inform the development of a national gender policy statement and strategy. So in that way, we would be able to achieve a sustainable development when it comes to equality. But really and truly, when it comes to that, St. Lucia really has, it's really on the back burner still, I would say. We're still in the consulting phase, but we are trying our best to see how we can, create the national policies and stuff for our people.
Good afternoon, everyone. My name is Jenny Joseph from St. Lucia. Thank you so much, Yakub, for that contribution. Just to clarify, yes, that ECLAC is supporting the development of the National Gender Policy Equality Statement and Action Plan, and we have also completed the Gender Data Management Assessment. Indeed. But in addition to that, we have initiated a self-starter implementation, if you will, of the Essential Service Package or the Essential Service Program for Victims of Gender-Based Violence. And we are presently conducting a comprehensive assessment of the services for gender-based violence in the various sectors, the social sector, health sector, and policing and justice sector. We are hoping that by mid-November, that assessment will be completed and a package of essential services is going to be produced. This process is being supported by UNFPA. So far, the initial, the preliminary assessment that we've done for the services for GBV in St. Lucia in March at our national consultation on GBV. It revealed that there were a lot of gaps, especially in the services provided for in the social sector. And so we are trying our utmost to do with the resources that we have and trying to gather resources from other friendly governments so as to be able to improve those services, to set up protocols where they don't exist and to tighten those that do exist. We just had a meeting, in fact, this morning with the subcommittee set up for that purpose and the consultant who is doing the assessment. And she's saying so far there are a lot of what is missing really is the information on those protocols. That some of the protocols are there, and the agencies that also know about them don't necessarily know about them. And the interagency protocols aren't really there. So at least we're trying to improve those services so that persons can have a greater confidence in the services that are offered in that regard. But overall, I wanted to say thank you very much, Roberta, for a very comprehensive presentation. You touched on many things that are very dear to us. We are in the state, we have completed the first drafts of the 7th to 9th combined CEDAW report for St. Lucia, and I'm very happy about that. The training that we received through Sisters for Change, and I must say that that training was with persons from various sectors in government. So we had individuals who were nominated to be national report drafters, and those persons were the ones who actually contributed towards the development of that first draft. And that's happening in much, much quicker time than it would had we done it the traditional means. So next week, Tuesday and Wednesday, we're having the second part of the training, where we are hoping at the end of the week to produce the second draft of the report. And the idea is for us to present it on the 25th of November to Cabinet. I'm really looking forward to that. But there's a lot that we can learn from the processes and so on that Roberta made reference to. I think that we still have a very long way to go in terms of tightening services for our people that we say that we are actually supporting to actually get the kind of support that we need. I also wanted to applaud you on the statement that you made with reference to the civil society working along with government. I think that sometimes we are, not necessarily agreeing on points that we need to agree on, that there needs to be a more collaborative effort, that sometimes we put the very people that we think that we're protecting at risk by the combative nature of the relationship. And so I would really love to applaud the point that you make on, working together and ensuring that we are on the same page, because what we want ultimately is to achieve the same goal.
Yes, thanks. Thanks, Jay. Jackie says that the Beijing 25 gives us an opportunity to engage young activists to share what those 12 points are and what actions were expected by government. So I think that's really important. And I would add to that, that the Beijing Platform for Action, under every critical issue, has actions that are for government, but also elucidates what are the actions that need to be taken by business sector, private companies, as well as other non-governmental organizations. So it's not just focused on state action, but also on non-state action. And I don't think we really have done a really good job of promoting what non-state actors should be doing to end violence against women.
If I may again, Jeannie again, I'd like to support that, but not just non-state actors. I think that the information with reference to the state obligations is not necessarily as widely known as it should be known within the government ministry as well, because part of what we recognize from the training that we did with the public sector and the private sector as well, of private sector, CSOs as well, for the development of CEDAW report and for the Beijing Plus 25 report, is that many people did not know about it at all and did not recognize that some of the data that they were gathering were contributing towards that. So we have to step up our efforts to ensure that this does not just sit within our bureau, but it becomes a national effort that people recognize and own the responsibility to protect, to fulfill, and to respect, the rights given under those conventions.
This is Elaine here. I would like to endorse what Jeannie said about making the human rights approach becoming more widespread in terms of women's rights as human rights throughout the whole of government. The situation she described is similar to what happens here in Grenada, and issues of gender equality and women's rights, including violence against women, are all treated as though, sometimes they're treated as though it belongs to the gender machinery and not as an entire government. Over the last few years, we have taken many initiatives to dispel that view, but it is not yet widespread enough. So I certainly endorse that that is something that, the use of the Beijing Plus 25 period can help us to address and to reach as a state where all state actors would see their role in ending all forms of discrimination.
Yes.
Good afternoon. Just like to make my contribution. Because of my experience in drafting our Beijing report, although it's not approved as yet, I was able to identify some of the progress that was made nationally, and also to identify the challenges so that we can be able to develop an action plan of what is to be done across the different sectors. And interestingly, I am a major part of the national mechanism for reporting and follow-up in the country that is chaired by the Ministry of Foreign Affairs. And being an integral stakeholder in that commission, I'm able to direct some attention as it relates to some of the contentious issues such as SRHR, SOGI, the CEDAW Convention, and even with persons with disabilities and violence against women. So much so that we are currently reviewing our sexual offences legislation with assistance from an organization in the UK. And from that review, recommendations are going to be proposed so that the government can be able to determine the next steps, basically. And we have also revised the sentencing guidelines nationally that covers all criminal offences. And we are currently drafting a sexual harassment bill, although it's just only in the workplace, but we are making strides nationally.
That's very heartening to hear, Lafleur. And what do you have? Do you have adequate data on reporting of all forms of violence against women and girls?
No, unfortunately, that was highlighted as a major challenge in our report. That's a challenge throughout the Caribbean on a whole. What we rely is on administrative data from the police, which is not it's not verified. You cannot verify it basically. But that's what we can do for the time being. Although we have would have had developed data collection forms, it's not being enforced at the district level in terms of the police. So that's, we even had to assign one of our staff at the police to assist with the data collection and to collect the information. But this is how far we are at, and we know our challenges, but the cultural challenges, that's the major hiccup, because what
Yeah.
they're saying is that it's additional work for them.
Yeah, but they're
It's
mandated,
additional work.
but they're mandated to collect it. So, the question again is
They are mandated
accountability. Yeah.
they are mandated to complete their police directory, not directory, the police diary.
Yes.
So in addition to this diary, they now have to complete a form.
Yes. So what we're saying is that there's no supervision. So when the constable or the person receiving the report does not do what they need to be doing, there should be consequences. There should be some review monitoring process.
Right,
But there's none
right. So
because middle
what
management and senior management is looking away from it.
right. So what, because over the past 3 years, we would have engaged the police in
Yeah.
some training as it relates to domestic violence and what's not. And we were focusing on the frontline officers, those persons who the victims normally would have first contact with. But what we found is that there's no enforcement or compliance because they are not aware
Yes.
based on the legislations and so on. So what we're going to do this year, we are going to be training the middle managers, even the top high-ranking police officers to ensure enforcement.
Okay. I want to share with you something that I think is interesting. So we keep on doing what we call capacity development. Um, I think it's much more than that. And I came across something which is a model of what they call institutional capabilities. And I should just send it to you all. But it's not just about training. Capabilities is a much larger thing. First of all, it's about leadership, which sets direction and motivates and builds the capacity of teams, right? So that's one thing, to implement strategies. But then you also think, so there's leadership, but then also there's the strategy. So you have the leadership, you have to have a strategy, what you're going to do, how you're going to do it, and then you have to deliver it, and somebody has to be monitoring that delivery. What we do with the police over and over in the Caribbean and with judges and magistrates is that we give them training. But we are not sure whether leadership is ensuring that the training is being translated into action or into delivery. And there's no strategy to take you from training to delivery. I should say there's no strategy. There's little strategy. So we have to start thinking, if we want to think about cultural and institutional change, we're going to have to go beyond capacity development, which in our mind is just about training, to something which is also systemic or structural, where you ensure you have leadership, and that leadership will be an accountability mechanism, because when somebody does not do their job, there should be a consequence. And we don't think about what those consequences are. I'm not talking about dismissal or so on, but something that can alert you to take a corrective action quite quickly. And that's what I think we need. We need to have an approach to what I call institutional capabilities, not just capacity development. And that, I think, includes this accountability for supervision of staff and teams, which, I think we have not really paid enough attention to.
Alexandrina here from Antigua. What we have written into our most recent Domestic Violence Act of 2016, duties of the police officer, where the police officer not only documents, but says to the complainant what her rights are, and also to say to the complainant, if you need assistance, I can offer you assistance.
Yeah.
However, although it is written in there, our clients have indicated to us that that information is not shared with them. Mm-hmm. So what we have done is written to the permanent secretary for public safety and explain the situation, and she is about to address it. In addition to that, how the police records are written do not give a clear picture of the type of violence that would have happened. They have a manner in which they document our record. So, Roberta, I think that is another area when we speak about capability that we need to explore a little further too. I am saying that because when we did our research here, we were working along with the police and they were able to share certain information with us. So when we looked at the information, there is no clear picture to say that it is a form of domestic violence. And so those are some of the areas that I don't know how your capability document is constructed, but maybe that is one of the areas how the documentation of the reports are being done could be looked at. Thank you.
Yes, that's really I mean, again, you have to ask the question. So similarly, in Trinidad and Tobago, which started all of this oversight in police and the law, the police have something called standing orders. And in Trinidad and Tobago, they have 2 standing orders addressing domestic violence, which tells the police step by step what they should do, what they must do. And actually, they're really very good documents. But the police don't even know these documents exist. So I think you really have to have a system in place where you're constantly checking in with your police officers to know what they know, and also to understand why they're not using the instruments when they know it, and if they're irrational reasons, that there are consequences. Now, of course, the police will also say, oh, we're so burdened, and we have to make all this reporting, but somebody has to be supervising that. And so maybe that's some of the things that, we could do across the Caribbean. Maybe we can say, as a region, for 1 month, we will monitor the police. I mean, of course, that sounds a bit ambitious, but I mean, we could come together to ourselves to think about how we would get some of this information that we need for our advocacy, and also the pressure CARICOM to have a common approach. That we can say, let us assign people to be in the police stations for some weeks, 2 weeks for all across the Caribbean, and take notes about what they're doing and do some analysis of that. I mean, that might be pie in the sky. But I think unless you have some sort of oversight, institutional oversight, and then oversight from users and from interest groups like ourselves, we're not going to get the change that we want. Because I think all of this maladministration happens in the dark. It's invisible, Unless you have an anecdote, you don't know what's really happening inside of the police stations, and we need to bring it to light. I want to ask Farmala. Farmala is still there? Yes. Farmala, I want to ask you, what is happening with your data collection system in Antigua? Go ahead, Michelle.
Yes. I'm listening to the dialogue and the conversation from throughout the region, and especially as it relates to the police and the legal structures that are there to protect women. And in some ways, you're hearing the same stories for 25 years. At least I am. And it is a bit frustrating to keep hearing over and over this lack of investment or lack of will by the state to ensure the protection of women. And so I think we are doing, as you said, rightly said, Roberta, training over again, training, people come out, but there is not a culture of protection, equality, respect, human rights integrated in all the systems. And I feel that it is what we need to do to ensure that citizens demand the protection from the state that they need to have, and all citizens, so women and girls and the most vulnerable even more so. So maybe collectively as a region, that's where we need to be going, to be thinking of how can we have this collective action to change policy and to change the leadership as it relates to being very lackadaisic in ensuring our rights, that our rights are protected.
The question that was posed earlier by Roberta about the database and what's happening with our data system. So one of the things that we established is a national electronic database where we basically spent some time to agree on a standardized intake form that should be used by all agencies, including the police. And then we also did a number of training, put the frameworks in place according to the international standards for collecting gender-based violence data and so forth. We also allowed access to civil society organizations, so like Women Against Rape, and I know that Wong is presently on this call, on this training as well. The problem with the database in Antigua and Barbuda, again, is it comes back to the lack of use by the various agencies who have access. So, for example, we still have the backlog of data that the police has not inputted into the system. We still have other agencies who have not been putting in the data in the system. So we have had to switch as well to a paper-based system that also allows us to collect the necessary data across various indicators from the different agencies as they submit them to us. We do have administrative data in the Support and Referral Center that we collect and we report to our stakeholders on a monthly basis and quarterly basis on the number of persons who have accessed the services here in the Support and Referral Center. I just wanted to make a point too about some of the discussions around leadership and coordination, because in Antigua we have, at the Directorate of Gender Affairs, established a coordinated approach where we host quarterly coordination meetings with all of the stakeholders who are responsible for responding to gender-based violence, and that would have been facilitated through the signing of memorandum of understanding and agreements between the agencies. So we do have agencies who come to meet with us every quarter across the justice sector, health sector, social sector, civil society, and so forth. I think though, and I think Roberta spoke about the steps for managing results, which is very important, because even though we do have that coordinated mechanism where we do meet, there is still a lot of challenges and gaps around the actual procedural and case management process and the use of protocols and actually adhering to the various steps that are required to ensure quality services. So that's a significant challenge that we have been monitoring, and also the accountability systems that would be necessary to assess the quality of services that we have been providing, not just within our center, but across the different stakeholders. So managing that referral process and ensuring that there is quality of services being offered. One of the ways we've been able to manage that, though, is that we have agreed on a M&E framework collectively among agencies where we would be distributing a number of evaluation forms and assessments, and we will come together and sort of assess the results collectively as well. Another challenge that we've had, and it's again around policy as well as the actions, is linking the initiatives that we do in the Bureau and among civil society and social sector with what is happening in the justice system. And that is something that we were able to make some gains in somewhat with the support of the Jurist Project with the Sexual Offences Model Court. So now we have a closer relationship with the Office of the DPP. And so we have also brought the prosecutors from the Legal Affairs Ministry into the coordinated system that we've established. So what we do is that we basically use the mechanism to hold stakeholders accountable. So from the police reporting all the way up, we try to find out where is it that the gaps are happening and how is it that we can work together to close them. So for example, the DPP would indicate that they would put systems in place to ensure that everyone who they are working with every client that they work with or every victim would receive court preparation sessions, will be offered support services. But of course, we know that those services should have been offered at the point of reporting at the police level. So then we would have to ask some serious questions to the police about what is happening at that level if persons are getting to the court system without any form of referral or access to support services along the process. So it's definitely a huge multi-sectorial approach which we all know and agree to, and we'd be happy to share some of the lessons that we're learning here in Antigua with everyone as well. But I think having all of the stakeholders face each other nationally on a quarterly basis is one of the ways in which we have started the work to holding each other accountable. Thanks.
Thanks for that, Famala, and all of the other colleagues have also spoken.
I think we have all the pieces. We all know what has to be done. We need to drill down to prevention. We need to, really get deep into the national psyche, the regional psyche on the things that enable equality and disable violence and discrimination. I think there's a lot more work. We talk a lot more about aggressive masculinities and working with men and boys, and that has to continue. I think that has to scale up, but they have to take responsibility for it, and we have to encourage that. But I think we've not really been doing, somehow along the line, working with adolescent girls and boys, and especially adolescent girls, seems to have gone by the wayside. How do you build self-esteem, life skills, decision-making, expectations of your life and yourself, which is based on autonomy and fairness. I think we need to do some more of that, which is the prevention work. We have to think a lot more about what we do by way of prevention. It just cannot be our annual campaigns. I think it has to be concerted, community-based, school-based work and ongoing to transform the culture in the way we expect it to be transformed. And I think this is about intersectionality. We have to break down those who are more vulnerable, break down the categories of those who are more vulnerable and who have least chance to escape. And economic justice, I don't want to say empowerment, I want to say economic justice is a big part of what we have to be working for. And then thinking again about those especially at risk for exploitation and with reduced capacity to resist. We have to be thinking in all of the corners of our conversation. And then, making demands of our community and the state to be involved. And it's not just to come and ask us what you have to say when somebody is killed. It's more than that. That when somebody says, what do the women's organizations have to say? Like I would say in Trinidad and Tobago, they would say, what does Hazel Brown have to say? Well, no, what do you have to say about what has happened? And somehow we have to find a way of demanding a greater involvement in this task. And maybe it means having a narrative or new language to describe what we're doing. I'm not sure. But I think we have to talk a little bit more about our strategy to bring new actors to join this, not on the basis of being allies, but being responsible for ending violence against women and girls. And yes, and this institutional accountability, I think we're quite a ways still from it. I don't think it's an accountability that's well enough shared by the police. I think the courts are getting there, and I mean, all praises to UN Women and CCJ and URAP for the work, what you all are doing. But there's that kind of concerted work that we have to be doing to change organizational culture as well. And then I think we have to be more monitoring the responses. How do health sector workers deliver their services? What's happening in the courts? That monitoring framework, we need to know more. And then we just need to celebrate our achievements, because I think the women's movement has achieved a lot in this area at national level and at international level. And I would say finally, I would really hope that we can use this Beijing Plus 25 as another opportunity to bind ourselves together, to really have regional solidarity, to be connected, and to plan together and to work together, not just to be in our little isolated spots at national level. We need to encourage each other, and we need to support each other's work. And we can only do that with more sharing. I mean, these kinds of fora that UN Women and IGDS have provided for us. I think we just need to keep on doing this.
Thank you so much, Roberta, for and I think this was a really useful, robust conversation. And I hope for those of you who are going to be going to Chile in November, this is going to be informing your thinking with regards to the negotiations. Roberta, I know you touched on it very briefly, but the issues that are considered challenging issues in the Caribbean with regards to discrimination and anti-discrimination, I think it was critical for all of us to hear where Caribbean jurisprudence is heading, as well as where we have already been. So I want to really thank you for your time, your energy, and your information, and all of the brilliance that you can consistently share with us across the region. Thanks again to all of you who have participated. As you know, this is the second day of our course, and Shelly Ann Hart from Trinidad and Tobago, who works with the National Gender Machinery there, has said Trinidad and Tobago has been working with youth in addressing violence against women and GBV through the UN Women Foundations program. They also engage school, youth institutions, and youth seminars on healthy relationships, which include topics on GBV. Thank you for that. Thanks to everyone, and we look forward to your full participation again tomorrow. Have a wonderful day.